Hello to everyone. I am Denard. I am an associate professor, and this video relates to sharing knowledge on the EU. This video is funded by German activities that I and my colleagues have won. Without losing time, I would like to immediately start with the video of today. So, the video of today relates to the freedom of movement, and it focuses in the case of the professionals. So, as I stated in the previous video, freedom of movement is one of the main values of the EU, and therefore the EU nation coming from different states cannot be limited, and they have the right to move within the EU. So the freedom of movement has been established in 1986 in the European single market. And the freedom of movement relates not only to goods, services, and capitals, but also to persons. Focusing in the case of persons, the freedom of movement means the right to look for a job in another EU country, to stay there, and to stay also after finishing the job. And obviously, the person enjoys the same equal rights as the local nations. However, this right might have some restrictions, such as public security, public policy, health grounds, or the employment in the public sector. So, for example, a judge or a civil servant working in a country does not have the right, freedom of movement to move in another country and to ask the administration or the judiciary system of that country to be part of that administration or of that judiciary system. So, the freedom of movement of professionals is extremely important. And there are two types of ways: when you take a license in the home country or when you take it in the host country. So the cases deals with a person who took a license in one EU member state and would like to exercise the profession in another EU member state. As I stated, since it deals with the freedom of movement, the countries cannot restrict this right. Therefore, I might be an engineer in one country and then decide to move to another country and exercise my profession and my license in the other country. In the case that this profession is ruled by special rules and people are registered there, still I have the right to exercise it. However, countries might make some restriction, but this restriction cannot deal with the language, because this is what the case law the case law of the European Court of Justice has established. However, after staying there for a period, then there is an automatic recognition of the license that they took it before. Let me make an example. For example, in the case of a lawyer, that he is a lawyer in one EU country and then he would like to exercise his legal practice in another EU member state, it will be done in this way. Immediately, he can have can make consultancy without any problems, but he cannot directly exercise the right to attorney, so meaning to represent a person in front of the judge. And also, starting with the case law and then also codified in the directive, for a maximum of 3 years, he has to have also the signature of the local lawyers. However, after these 3 years, there is an automatic recognition of the license of the lawyer that he took from another EU member states. And the language requirement is not one of the requirements in order to have an automatic recognition of the license as a lawyer. In fact, this decision that I have underlined in the slides deals with the lawyer and with the Luxembourg law that required that lawyers needed to know the local language. So another thing that I wanted with you to share is the liability that professionals have. And the two main liabilities are contractual liability or tort liability. And this act from the moment of capacity, which means from a moment of birth, or from a moment of competence, which means from a moment that you are able to sign a contract, which generally is 18 years old or earlier, for example, in the case of emancipation. The damages that you are going to pay are different if they are in the tort law or in the contractual law. In the contractual law, you are liable only for the damages or loss that the person knew at the moment that they signed in the contract. In the case of tort law, the person is liable for all the damages that are a direct result, immediate consequence of its behavior. Regarding the prescription, without going into details, and there is a difference between country and country, but in general, the contractual liability is 10 years and the tort law is less, and in general, might be 3 years or 5 years, depending from state to state. But what I would like to focus is the burden of proof. While in the tort law, the plaintiff shall prove that the defendant have committed a tort, the damages, so the plaintiff has suffered some loss of which he or she can be compensated. There is the need of causal link between the defendant's behavior and the civil damages, which is done through the balances of probabilities, and the plaintiff shall also prove the negligent fault of the defendant. While in the case of a contractual liability, the plaintiff shall only prove the contract, there is an existence of obligation, and this obligation was not fulfilled. Then the defendant shall prove that the absence of the fulfillment is not attributed to his behavior. As you can see, the burden of proof is really important in case of civil damages. And in order to protect consumers, the EU, but also national states, are focusing and are shifting the liability of professionals from the tort law to contractual law. So let's make a premise. We have the contractual liability, as I stated before, but we also have pre-contractual liability, which is the contractual liability during the negotiations. And in this case, the person is liable for the negative interest on the contract, which means that has to give all the expenses incurred during the negotiation and the loss of the opportunities. So in simple words, I came in the negotiation here and I lost the opportunity to sign a contract with another party. And this means that you have to pay for that. Now, as I stated, there is a shift from the tort law to contractual liability. Why? Because it's much easier, and for the consumer, in order to protect them, it's much easier for the consumer to prove the liability of the counterparty. And everything started in Germany with the Article 311, Section 2 of the BGB, of the German Civil Code. And basically it was stated that there is sole liability in case that there is a trust. And there is a link between the bank and the client. So for example, at the moment that I enter into a bank, I am sure that the bank is going to is going to fulfill all its obligation for having a security within the bank. And if in case that I'm going to be robbed within the bank, then the bank is liable and the bank is going to reimburse and compensate me. And the same is, even if the bank is going to pay a checks to other person in case that they have falsified it. Another example that the doctrine in the case law have established is in the case of teachers. When children hurt themselves or they hurt others, still teachers are going to be liable for that. Another case is the case of the doctor in the case that it's not a contract. There is also the case of lawyers, or can be engineers or other professionals. When there is an absence of the contract, the lawyers, the professional, has taken a reward in order to perform it and is not part of its obligation established in the register and the obligation that the professional has. And what is more important, there is a trust between the counterparty and the person that is a professional. So, as I said, there is a functional link, and the most important, there is the defense of the trust that has been created since the counterparty has a social status, the status of being a lawyer, an engineer, and therefore everything that he or she is stating is part that which might be part of the profession, then he is going to be liable of that, although there is no contract. This because the tort law, as we saw before, is much more difficult in order to prove, and therefore there is going to be a contractual liability. Another thing that I would like to share some knowledge with you deals with the minimum and the maximum tariffs. But before going there, I would like to underline the fact that obligations are divided into obligation of means. So there is the need that the counterparty use the ordinary diligence of the group of the people that are doing that, and is the case of the doctors, of lawyers, of engineers, and there is also the obligation of the results. When there is the result, which means in case that I'm going, for example, I'm going to order a book, I would like to have a book. I do not want to know that you use the ordinary diligence in order to print or bring the book. I want just the book. And in this case, in case that I do not have the result, then you are not fulfilling their obligation, and there is a contractual liability. There is the possibility to transform the obligation of means in the obligation of the results, but I have to underline that this is only regarding the payment. So, for example, I am going to represent a person as a lawyer, then I say to the person that if we win, I take 20% of the total payment. If we do not win, I take 0. See, so that is an obligation of the results, but it only deals with payment. The diligence is going to be part of the obligation of means. So if I represented the person correctly, then I'm going to check the ordinary diligence of the lawyers for that particular case. Now, why I was doing that is because there is a huge debate in the doctrine and also in the EU level if the minimum and maximum tariffs for professionals are aligned with the EU law. And while the maximum tariffs are not aligned with the EU law, and that is what's stated in case, for example, of engineers, and this is the case law 377 of 2017. In the case of minimum tariffs, so for example, there is the joining case of 94 and 2004 and 202 of 2004, which dealt with Italian lawyers. The minimum tariffs might be aligned with the EU law if this might avoid the inefficiency of the service provided. So, in the market where there is a lot of professionals, in order to guarantee the efficiency of the service, the minimum tariffs can be in line with the EU law. So this is the case, or for example, in Italy, but also can be in other countries, where there is a huge number of lawyers. And in that case, in order to guarantee an efficiency of the service of lawyers, then in that case, the minimum tariffs can be aligned with the EU law. So, the freedom of movement is one of the 4 freedoms guaranteed by the EU. In the case of professionals, they do have the right to look for a job within the EU without having any restriction, without asking for a residence permit. While the maximum tariffs are not aligned with the EU law, the minimum tariffs might be coherent with the EU law under the condition that this helps efficiency. I would like to thank you for listening also to this video, and I hope that you are going to join on the others video.